Welcome to Literary and Jury Charge Practice. Let's start out with some jury charge. Ready? Here we go. As I told you earlier, it is your duty to determine the facts. In doing so, you must consider only the evidence presented during the trial, including the sworn testimony of the witnesses and the exhibits. Remember that any statements, objections, or arguments made by the lawyers are not evidence. The function of the lawyers is to point out those things that are most significant or most helpful to their side of the case, and in so doing, to call your attention to certain facts or inferences that might otherwise escape your notice. In the final analysis, however, it is your own recollection and interpretation of the evidence that controls in the case. What the lawyers say is not binding upon you. During the trial, I sustained objections to certain questions and exhibits. You must disregard those questions and exhibits entirely. Do not speculate as to what the witness would have said if allowed to answer the question, or as to the contents of an exhibit. Also, do not assume from anything I may have done or said during the trial that I have any opinion concerning any of the issues in this case, except for the instructions to you on the law. You should disregard anything I might have said during the trial in arriving at your own findings as to the facts. While you should consider only the evidence, you are permitted to draw such reasonable inferences from the testimony and exhibits as you feel are justified in the light of reason and common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the facts which have been established by the evidence. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of one who asserts actual knowledge of a fact, such as an eyewitness. In other words, when witnesses testify about what they know by virtue of their own senses, what they see, feel, touch, or hear, that is called direct evidence. Circumstantial evidence is evidence which tends to prove a disputed fact by proof of other facts. A simple example of circumstantial evidence is as follows. We will get to that example later. Now let's try some more literary material. And this is one we had started previously on Chris Rice. Ready? Here we go. Not everyone learns the same way, but at Journey, I have been shown how to work through this world, which is a lot more difficult than some people may believe, Rice said. College was never in the cards for Rice, or so he thought. After earning his GED, he was eager to get back out on his own. He went straight into the workforce at 17, delving into various manufacturing fields. But it was not enough. I realized a million mistakes later that I needed to get a degree, and once I did that, then I could really travel the right path that I knew would be a good one, Rice said. Journey remained by his side through both emotional and financial support, helping him get into his college of choice, University of La Verne. As a business administration major with an emphasis in international marketing and human resources, Rice is now on the road to a brighter future. He works for an internet company and plans to open his own business one day and ultimately help others. Going through journey and now being at Laverne, where the campus is so diverse and accepting, I have changed for the better. You can never let anybody take you out of your zone, and I am glad I finally found mine. All right. Let's get back to some jury charge practice. Ready? Here we go. Assume that when you came into the courthouse this morning, the sun was shining and it was a nice day. Assume that the courtroom was without windows, as this courtroom is, and you could not look outside. As you were sitting here, someone walked in with an umbrella which was dripping wet. Someone else then walked in with a raincoat which also was dripping wet. Now you cannot look outside the courtroom, and you cannot see whether or not it is raining. So you have no direct evidence of that fact. But on the combination of facts which I have asked you to assume, it would be reasonable and logical for you to conclude that it had been raining. That is all there is to circumstantial evidence. You may infer on the basis of reason, experience, and common sense from an established fact the existence or the non-existence of some other fact. The law makes no distinction between the weight you may give to either direct or circumstantial evidence. You should consider all of the evidence in light of your own common sense and experience, and you may draw reasonable inferences from the evidence. I remind you that it is your job to decide whether the government has proved the guilt of the defendant beyond a reasonable doubt. In doing so, you must consider all of the evidence. This does not mean, however, that you must accept all of the evidence as true or accurate. All right, let's stop there and get back to some of our literary material. This is called Capturing a Piece of History. And this is an article from our NCRA magazine, the Journal of Court Reporting. Let's give this a try. Ready? Here we go. When the National Court Reporters Foundation first explained its involvement with the Veterans History Project through the Library of Congress in 2003, I jumped at the chance to transcribe a real-life interview with a war veteran. I'm a history buff. My favorite things to watch are the History Channel and PBS. And I could give you a pretty good rundown on World War I and World War II. Participating in the Veterans History Project seemed like the perfect opportunity. The first few veterans interviews I transcribed were on cassette tape, which tells you how long I've been transcribing. In many ways, the challenges are the same as those you run into every day with your normal work. Sometimes you can't hear clearly. Sometimes the interviewer doesn't ask the greatest questions, and most of the time you have a fair share of research to do, so it's like a typical day at the office. Doing the research for me was enjoyable, as I was able to use some actual books on my shelves. I'm sure Google would have been faster to find very specific locations of battles and major events. All right, let's stop there. And that will conclude our literary and jury charge practice.